We got about 5 minutes till showtime, everybody. Everybody would start turning their cameras on. We have about 1 minute till showtime.
Thomas, it tells me the host won't let me turn mine on. Can you help me with that, please?
There you go.
Sir?
Yes, ma'am.
Hi, everybody.
Hi.
It's been a year. I've missed all of you. I know you don't miss me, and that's okay.
Well, we do.
Madam Chair, whenever you're ready to start, you can call to order.
Bear with me as I go through the technical side of it, but I'd like to call to order this meeting.
Okay, and just for the record, this is the February 11th Independent Ethics Review Board meeting.
Yes. Okay. Thank you. Sorry. And apologies as I fumble through some of this. The first notification that I was chairing the meeting was logging on. So this will be,
I apologize. You were supposed to be notified last when you were appointed the chair.
it's not a problem, but I'm in private sector corporate board mode. So if I need to motion or move for a vote or an adjournment, please just, guide me in that direction.
Not a problem. I'm very good at doing that. I've got a few years experience. So if you have a copy of your agenda in front of you, I would recommend we just go in order, starting with the public comments. If you would read that paragraph, please.
And Madam Chair, I'd be glad to help you out. The public comments is for citizens who desire to address the board with regard to matters on the agenda to be received at this time. Members of the public have been invited to make their comments to the Office of the City Secretary via email, and we have no public comments signed up at this time, Madam Chair.
And Thomas, is this attached in the email? Because my email has the 6 articles, the resolution, and I also have the code of ethics pulled up, but for whatever reason, I don't have the agenda attached.
Same here. I didn't get the agenda.
Okay, apologies for that. And I'll guide you through the agenda for today.
You can also find it on the web, the city's website. We'll make sure we get that.
And the next item, Madam Chair, is the minutes, consideration of and action on the minutes of the February 13th, 2020 meeting. Those should be attached in your email, and if not, we have it posted in the chat for your review.
So minutes review, anybody have any changes or adjustments to the minutes?
Nope.
Looking for a motion to approve?
I make a motion we accept the minutes as written.
I second it.
Minutes approved?
Well, can we take a
Can we
vote?
take a vote?
I'm sorry.
Just all those in favor, they could just signify by raising their hand saying aye.
Aye.
And any opposed, same sign. Okay. All right, Madam Chair, they pass.
I just have a question. When were the agenda items sent out? Was it sent out for the first time yesterday night?
Yes, ma'am.
Okay, because that just didn't allow much time for review.
I understand.
Okay.
I will work on that in the future. It's been a year since I've had an opportunity to do all this, and you may notice that Daphne is no longer on this call. As our liaison, she has been reassigned, so you're stuck with me and no liaison. So I promise when we meet the next quarter, I will be more organized.
All righty, Madam Chair, the next item on your agenda is for a review and discussion on the ethics articles of interest. So I will.
So did everyone receive and have a chance to review the articles?
Yes.
Do we want to go through all 6 or do we want to take any articles of interest for discussion?
Can we look at the Eagle Pass one?
Yes.
I thought that was a good one.
What were your thoughts and comments around the article itself?
Here they are, they're an independent city, but they're getting an outside perspective on, look. I just thought that one was interesting. That's basically what it is.
Sure, I
We
included
could
this
review
one
it.
because the charter has provisions related to term limitations.
Right.
Although this is not included in your code of ethics, this might have been a complaint that might have come before your board. Although you would not have had jurisdiction, I think you might find it interesting on the differences of opinions on how you can count up to 8.
That extra term, that could very well happen here in in any of our, nearby cities, I think. How long do you count a term? That's why I like that one in particular.
Yes, ma'am. Interestingly, under the charter and the one that was just approved this last November, we do have a total number of years that can be served. So that takes into effect whether or not you've been appointed. And so they do say 9 years total. So you would be able to serve 1 year of an appointment. So it's possible that you may not be able to serve a full 8 years in Sugar Land, but you could serve at most 9. But I
think the wording probably changes it. Is rather than number of terms, number of years.
Right. We say 2 consecutive terms for a time not to exceed 9 consecutive years. But so when I pick these out for you, I try to find some that are close to ethics, but may also be of somewhat of interest to you as just an insight into some of the nuances in government. And you'll probably be happy I had 40 articles and I did narrow it down.
Thank you for the 6.
I just want to address the point of hiring somebody from outside. We have that in our policy as well, that if the city attorney has to recuse themselves for any reason, that we would default to the DA's office, county DA's office, as our outside source.
Not that would be for criminal charges. Under this board, if this had been a real hearing today that you're having instead of a mock hearing, we'd actually have outside counsel giving you direction, as I would be conflicted because I was the initial reviewer of the complaint, and my office has the responsibility to write the get out of jail free cards if requested and applicable. And so we would hire outside counsel to guide you through any future hearings. But for today, we decided to cut costs just a little bit, and you have to put up with me during your mock hearing.
As a citizen, a taxpayer, I appreciate that.
Thank you, Mr. Fox.
Of interest from the articles themselves, I thought the San Marcos case incident was quite interesting. Did anyone have a chance to review the San Marcos Ordinance?
Which article number was that?
It was article number
3. This would be the code enforcement article.
Yeah.
And this is related to parking in the driveway and having a used car dealership.
And it was interesting that to me that the article or the actual case itself ended where it's still up in the air. I mean, it's gone on for years and years, it appears, and they haven't even decided whether or not that they would have a hearing on it.
So under our code of ethics, we believe that this person was receiving a benefit that the average citizen wouldn't? And do you think maybe the news media does not pick up on the influence they may be putting on staff?
I completely agree. I mean, I definitely think that, and it may be minor, but it's still an abuse of power to an extent, and definitely a violation of our code of ethics. At face value, without all of the details.
Sure, the media does skew things, but
Did anyone else have any comments on this particular article?
No.
Any interest in any of the other articles that were received?
I like them all.
I thought it was interesting, the Plano article in particular, that they're making a step in the right direction, but there's not a lot of teeth to what they've decided. So whether or not and I don't recall the article number, I apologize. Let me see. Basically they decided, let's find the article. It's Article 2?
Here's Article 2. Yes, ma'am.
There you go. So there's no consequence. And so when you look at ethics and compliance and things of that nature without any kind of teeth or consequence, it's a right gesture and a right step in direction, but until you're able to actually hold someone accountable, sometimes those efforts are in vain, in my opinion.
Andrew, maybe I'll
You're
give
right.
you insight as to the discussions that occurred when the Independent Ethics Task Force was writing the ethics code and the challenges they faced trying to come up with enforcement mechanisms.
Yeah, I think it was a couple of weeks ago we did that, but we wanted to set our parameters as tight as we could for what's considered a violation, and then make the punitive section as big as we could. So if the state said, if you do that to us, it's $50, we wanted to say it's $2,000, so that the punishments that we chose would be serious enough as a deterrent to the violation. Some of them I thought were pretty serious, right? It was a couple of $1,000 in penalties for some of the violations. And we wanted to let everyone read the document, see and understand that it wasn't just a piece of paper that we were going to say, hey, we created this and you should abide by it. If you don't abide by it, it's not going to be comfortable for you.
Which was the one where it said, well, he said he's sorry, and then that was it? Was it, I think, sorry, let me go back. There was one of those articles where the person says, well, I said I'm sorry.
Promise not to do it again.
I had 3 or 4 of those. I don't know which one I sent to you.
I think that was the Bee Cave City Council.
Yes.
Okay, I had 8 articles on him.
Andrew, I just wanted to say, when we were talking about how y'all wrote the code of ethics, I've written a couple of codes for different corporations, and I thought you did an excellent job with respect to, having consequences without overreaching. You also want to make sure that it's not so far on the spectrum that you're wielding too much power for this one particular board. So I thought it was an excellent job that it takes the code seriously, but it also doesn't overreach.
Yeah. We can thank Meredith for keeping us in line on that one. She's like, no, you can't put them in city jail for a week, steal pencils.
There is no death penalty in an ethics ordinance.
Yeah. I did have some questions, surprise. When I was reading the resolution.
Yes.
So it's a multi-part question.
Would you like for the chair to go ahead and move to the next item?
Oh, okay.
Does anyone else have any other comments around any of the articles or anything any other discussion about the articles that were received? No? Well, let's go ahead and move forward to the resolution and comments around
Okay.
it.
Madam Chair, so you're on a workshop item, which is conduct a mock hearing to practice hearing procedures consistent with the application of the city's code of ethical conduct. I will share the resolution with you all now.
I had different comments around it as well, but I'm going to go ahead and punt to Andrew if you wanted to go ahead and get started on the questions you had on the resolution.
Thank you. My question is, what constitutes a person accepting something? Is it them, their campaign, a staff member, a family member? And if I were to give money to a campaign and they're like, oh, that can't happen, and the person gives it back to me, if they cash the check, is it accepting the donation?
Yes.
Okay. If they take the check and they don't cash it and mail it back to me?
Then it does not hit a campaign finance report and they have not accepted it.
Okay, and what if somebody in the 5th degree of sanguinity, did I say it right?
Yes, sir.
Okay, whew, that was a big word we learned in the task force. So if somebody, family member or somebody accept that, it's just as damning as if the person themselves accepted it?
If you're at the 5th degree, no, sir, it is not.
No, okay, no, but so anything, the parents, grandparents, children.
Stepchildren, the ones you pretend to adopt that you haven't adopted, yes, they can be accepted, but your neighbor's kids can.
Okay. And what about campaign staff? What about if it's a campaign staff member who accepts it?
If it goes on the campaign report that is filed with the state, it's considered accepted. I'm not sure why campaign staff would accept something that wouldn't go back into the campaign. That is not in the ordinance, or excuse me, the ordinance.
And if they realize that it was a mistake and they return it immediately, are they still in violation?
I think that would be something that would come before you all, and you determine the circumstances at which point they determine it was a mistake. If it was a complaint filed against them, and you guys have threatened them, and they said, "Oh, my bad," and they give it back, this board may think of it differently than if they had gotten it and they went, "Uh-oh," and turned around and gave it back. So I think that is definitely something that this board would have to consider the circumstances related to that, and I couldn't give you a flat, straight line answer.
Okay. Of course, we would never have to deal with that in our city.
I certainly hope not. I think, Madam Chair, you had some questions related to the resolution?
So the resolution with respect to, I'm trying to toggle, sorry. The resolution with respect to the panel hearing procedures.
Yes. So in my message last night, this was adopted by City Council back in '06 under the other Code of Ethics. Last February in our last meeting, we had started the process of creating procedures, but we never got that far. In the interest of time, we decided to take the existing procedures we have and I'll mark them up as we go. So in our next meeting, I'll take the markups to you for suggestions. But I decided it might be easier to do the procedures in the context of an actual hearing, a practice hearing, so that you can determine, maybe have a better understanding of what procedures need to be tweaked and adjusted to meet your needs, as opposed to me trying to draft something that does not work for you.
That makes sense. Prior to actually looking at a scenario, can I ask a quick question regarding the proceedings that are listed currently?
You're the chair. You can ask whatever you like.
Perfect. Under the Section C, General Hearing Procedures, on number 3, it reads that upon the request of either party, the chair will order that all witnesses who are expected to testify in the hearing, other than the complainant and the respondent, may not physically be present to observe or listen to any of the proceedings, and it continues on. My question is, as this is written, do both the respondent and the claimant, are they both able to be present throughout all witness interviews?
Yes, ma'am. For those of you familiar with the courtroom proceeding, this is the equivalent of invoking the rule, where all witnesses step out, but the interested parties do remain in for all proceedings.
So with respect to that item, this is definitely written more as a trial hearing versus an ethics investigation hearing. So I just wanted to understand if that's the intent and that's what's appropriate, great. If it's more, if we need to lean more towards an ethics hearing and less, trial oriented, that's just a question I wanted to pose as far as, what's most appropriate for city government versus, other types of entities.
Sure. As a local municipality in the state of Texas, we are subject to the Open Meetings Act, and these have to be open to the public. And so these proceedings will be recorded and they will be live. And so whether or not you ask the person to step out, they can just pull up their phone or their iPad and watch the proceeding, whether they're sitting in the room or not. But under very limited circumstances, can we actually go into executive session to discuss this under personnel matters? But the City Council has made it quite clear that it's important to them that these procedures be done open in full compliance with the law, because they want the citizens to believe the process and to understand your rationale when you do make the decision.
Okay, that makes perfect sense. And I didn't know, is a witness able to request that the respondent or claimant leave the vicinity as they're questioned, even though it'll be open for, open record and can be reviewed and listened to and seen? Are they able to just, ask that they be removed from the questioning process itself?
I've not been asked. I suppose you can ask them to go into an adjacent room. And if criminal proceeding, you do have the right to face your accuser. And so they do have the right to sit there and watch. I mean, if it makes them feel better to turn the chair around, we could possibly do that. But this is a signed sworn complaint. And so anybody who participates in the process needs to be open and honest as to what they're doing.
Right. I'm just thinking of a third party witness. So if somebody who, didn't swear to the complaint and is not directly involved is asked to come in for questioning, yes, they'll take the oath, but do they have to sit in front of both of, looking at intimidation components? If something's coming across a very prominent council member and, a witness is actually concerned and scared to provide information.
I think it's going to be a case-by-case basis, and the outside counsel that is representing the board at that point in time can advise you based on the information they have during that hearing if they do believe a threat to exist. I suspect that the council member or board member who, if they are up to losing their position, may also have legal representation, and they will also offer an opinion. So I know that's but I do believe it would be based on the facts of that day and the attorney representing you for that hearing.
Okay. Did anyone else? I have a few other questions, but I wanted to give other people opportunity to speak, ask questions, make comments.
On the first page of the resolution, it says that it will be heard by a review panel consisting of council members who are not subject to the complaint. Isn't that our responsibility?
Yes, sir. This adopted in 2006 under the
Right.
old. We are going to be revising these today as you go forward. So I would recommend that you start on page 3, general hearing procedures, because everything above that has to be changed.
Okay. One thing in section B under administrative matters, section 2, where it talks about the city secretary maintaining all audio and video recordings. Should there be a mention of how long they have to be stored? I think the city generally stores stuff for 18 months, but in this case, it's stuff that could come back a decade or so later.
Yeah, for all of our records management stuff, including these type of hearings, we follow the Texas State Libraries and Archives Commission retention schedule for local governments. So that's the retention period we would assign to this, unless of course there was some legal suit or anything like that would make us keep it longer than that retained period.
Anyone have any idea how long that is?
I can look it up right quick. The schedule's online. I can look it up right quick.
Okay, because I know all of our emails and stuff are saved for 18 months. But in this case, if somebody can serve 9 years, that 18-month period is not going to be long enough. I don't want to make extra work for the city secretary, but
I think you make a valid point, and we'll look into whether or not we should keep it while the person is in office plus a certain number of years.
Because I could be city council for 9 years, take a year off, come back as mayor. I'm not planning on doing any of that. But if I've only had a year off and then you find out I did something as a city council member and now I'm a mayor, you should have the right to follow that up and have all the documentation you need.
This is true, but do you remember the code says that it's 1 year within date of incident or within date of discovery. If
Right.
it's a result, it may be difficult to discover.
Okay.
But yeah. Excellent point.
So don't pay me for it.
Sometimes they make you bring food.
I'll do that. As you can testify, I'm a pretty good cook.
If you make good barbecue, the task force would say so, yes.
So, and just to kind of put the tight bow on the question that was asked, the records retention schedule for this is resolution or dismissal of the complaint plus 2 years. So basically 2 years after the case is dismissed or a resolution has been rendered.
Okay, so that really doesn't cover us if somebody did something and it was found out later, does it?
Yeah.
And so it's the resolution or dismissal plus 2 years. I want the evidence preserved prior, before that.
Well, the evidence will be attached to whatever this board makes the determination or complaint files. So if it wasn't discovered during that process, we would have to have some sort of other documentation and we wouldn't know to keep it.
Okay.
But you definitely have for us to think through. Yes, ma'am?
Doesn't that all adhere to all of the TPIA requirements too?
As far as you're talking about the Public Information Act?
The Public Information Act requires us to keep documents that reflect the active city business. And so if it's an action outside city business or it's not something that's captured like they're getting a bribe, we won't have a record of that because it will not go through our system.
Okay.
If it goes through our system, I will be the one signing the complaint. We'll have all kinds of craziness ensuing because that's never happened.
Makes sense. Are there any other comments on the actual hearing procedures?
I did have one more question, and then I won't answer. I didn't ask any more questions on this. Does a conviction by somebody preclude them from holding an office in the future?
Yes, sir.
Okay. So if I've got misdemeanor C or above or moral turpitude 3 years ago, it bars me from running?
Not a misdemeanor C. The charter election and state law have been updated so that it's moral turpitude. And I believe there's certain class A's and B's that are considered moral turpitude, but you will not have a class C.
Okay.
You can serve with a traffic ticket and a registration. That against you.
Okay, so we'd be able to say you were convicted of moral turpitude 2 years ago, you can't even run for city council.
That's correct. If it's a final determination, not appealable. Yes, sir.
I like that.
This was y'all's recommendation last year when we took it to the voters. This board did make that recommendation and council adopted it.
I like that. I don't have anything else in that document.
And Ted, Mary, Rachel, Fred. I just want to give everyone a chance to speak and have any commentary on the procedures rather, before we move to a scenario.
So I have a comment or question. It goes through the procedures of presenting evidence and asking questions. Is it clear when the board itself can ask questions and at what point it's proper for us to do so?
That is part of what I would like to work on today. is to have more in-depth procedures. So we'll have the standard things like you do at the meeting, you call it to order, you swear in witnesses. But I would like to include language that you have the right to ask the questions and that you are the investigators. And then after you have your questions, the other party may ask questions of the witnesses. But I would like to draft this in a form for running the show. The chair directs who speaks when, but the chair directs that you all ask the questions first.
Yeah, I think it says in number 8 that we can ask questions. I'm just wondering, I would think we'd want all of the attorneys to ask questions, and then maybe we ask questions after that, perhaps.
You can set it up that you can ask questions at any point in time. But I would prefer, if y'all will consent, that you have the right to ask the questions first so that you are directing the direction of the hearing and that you can keep it on topic and it's not complaints that are not part of the packet in front of you.
I definitely agree with that. I think it's really important as an independent board to make sure that the proceedings and the topics that are discussed are directly related. And I think too, it can also prevent more heated exchanges too when it's directed from an independent body.
So this is a very good overview that was adopted before. I recognize that it needs a lot of work and I would like to put a lot more detail into it. I think that these are great questions and I encourage you to keep asking them, but I want to reassure you that as you go through your mock scenario, I am going to take notes and I am going to put together a draft for your next meeting as to procedural steps. So you almost have a checklist as to opening, closing, questioning a witness, cross-examining, following up, and that sort of thing. So your questions are prompting me to make sure I provide you a very thorough document. So please keep them coming.
Based on those comments, why don't we select a scenario to go through and conduct? Do we want to vote on a particular scenario, or Meredith, are you wanting us to go through all three?
I don't believe you have time for all three. I would recommend that you all decide what you want to do. In the interest of time, we went ahead and tried to make them short and kind of give you directly the violations as if you had received the complaint and recognize that you don't have witnesses to question. Part of this is to also get through your thought process to make sure that you think the ethics code is sufficient. And if we need to make amendments, so we have time to take them to council in the unlikely event anything ever comes up. But this is a good time to have another review of that as well.
Okay, great. Of the three scenarios, there's 2 of council members and 1 of an administrative board member. Does anybody have any preferences in which scenario or recommendations?
Go for it, Madam Chair.
Okay, I personally, since no one else has spoken up, I would like to do one of the council member scenarios versus the administrative board member. I vote on scenario 2. Does anybody else have any other preference? Okay, well, let's move forward with scenario 2.
So with scenario 2, assume that you have been provided a copy of a signed sworn complaint and it meets all the requirements and that my office has signed and stamped it and it is now brought before you. You have called an open meeting pursuant to state law and you have done all things necessary prior to conducting your hearing. And go ahead and jump to the part where you have already gone through all your witnesses and you determine the facts in the scenario are to be true, and then start your deliberation process. And I will take notes so that I can set procedures to streamline your discussions and any additional information you may need in the future.
As a conflict of interest issue, I think the first thing that we would do and Meredith, I'm sorry, I'm going to pause. Are we needing to go? I was going to look at the deliberation of one where we look at jurisdiction. Do we need to just jump ahead and say that, yes, this meets the code and it meets our jurisdiction to move forward, or is that part of the deliberation?
You know what? Do what works for you, because I'm going to write these procedures to reflect what you all decide is the best process for you all. I have independently determined that the person that the complaint was made on is subject to the board, and that the complaint alleged is subject to is within your purview. I have not made any determination as to whether the complaint is actually a violation of that. I have just said, yes, this person is subject to the code, and yes, you have jurisdiction.
And it's within the time constraints.
Yes, yes, ma'am. But you definitely have the right to independently make that determination as well. I make mistakes, and if your name's going on the bottom of this, you probably want to make sure I was right.
I think that's a great idea and easy thing to move forward at the very beginning. So I think one is the timeliness, that it's filed within a year of the within the incident or the complaint. Two, the person that's being accused is subject to the code of ethics, and as a council member, we would say yes, that this individual is subject to our code of ethics. Three, the conduct must be regulated by the code of ethics. So I don't want to be the one doing all the talking, so I want to ask, do we feel that the actual incident or the complaint is subject to the code?
I want to make sure that what they're being accused of is something that we have jurisdiction over, and that it's something that if we decide they did it, that it is a violation. Before we go and spend the time, did they do something and what do they get? What's the punishment? Does it violate the code? Do we have authorization and jurisdiction over it?
Krista, when a person is sworn into city council, isn't that part of the swearing in, that if there is a conflict of interest, you will bring it up? So it isn't like the person, that particular council member didn't know that he was going to directly benefit. And I think that's a phrase that comes back to me again and again in different ethical issues. Was there benefit? Yes, they did it, but they benefited. And that right there, if he's a definite beneficiary, then it makes the whole proceeding run faster, in my opinion. Right? If you can show that, hey, he sat there quietly, let it happen, and then benefited from it, the party bringing in this issue is not wrong.
I definitely agree. And I think, there's a couple of issues at hand. It's the direct conflict of interest that occurred, or that we're discussing, whether or not there was a conflict, but then also the abstention issue as well, that he or she did not abstain from the vote itself. So not only did somebody receive a direct benefit that was not disclosed, that also the council member did not abstain from voting on the award as well.
And we talk about acts of omission and acts of commission, right? And this is definitely an act of omission. You sat quietly and allowed it to happen and didn't say a word. And I think public figures, particularly city council or, people in positions of power, that has serious consequences to the general public. Like if person A does something, okay, you know what, that wasn't cool. But if you're in a public position, the fact that you benefited and the fact you sat there quietly has greater consequence, or it means more.
And I think it means more too, in directly related to what's outlined in the code of ethics, that you know, that you received the benefit of a certain amount. You know, we don't know that it says all equal beneficiaries, so we can assume the dollar amount is well above the threshold that's outlined in the code. Something that I looked at as well, it says that the council member was fully aware at the time, so that there's not a plea of ignorance here, that they weren't aware that they were the beneficiary of some trust in their name that you know, was out there but wasn't aware, so that they did know that they were going to be benefiting directly from this this purchase. Anything else that you looked at when we were reviewing the case itself, and I mean, up for discussion, things we might need to know more of or request information and details for?
I think you bring up a very good point. How much? What was the benefit, the possible benefit? Because if it falls under the threshold, they can always bring that back. But if it's above the threshold, it might help for us to know that.
So in the threshold for financial benefit is any money or service, license, permit, contract, loan, travel, entertainment, which is, so there is a limit for receiving gifts, foods from contractors. For something like this, you receive $1. It's anything. The code doesn't specify a minimum limit.
Okay.
That is Section 275 under custom. Let's see, 275, page 5, financial benefit. It's the third paragraph in, if you want to see it in the code.
It seems like everything in that last statement is a legitimate reason for bringing this before the board. So not disclosing the conflict of interest, not abstaining from the vote, not filing a conflict of interest. I mean, those are 3 violations against the code, right?
True.
Yeah.
So is there any other documents that we would need to review, or anybody we would need to interview or investigate further outside of these facts? I mean, it's very straightforward as how it's being presented to us, which is incredibly nice. So there's not a lot of gray in this particular scenario, in my opinion. But I mean, you know, we would want to know, I guess we have the purchase price of $100,000. We have the vote itself. The other question that, and then perhaps it's in there and I overlooked it, but would the vote have gone forward if it said that, I believe there was still a quorum without this particular council member, but would the vote have gone forward if this person abstained? So was it by one vote that this purchase went through? I mean, that's something that I would want to know is, you know, was it everyone voted yes to purchase this field at this price, or if this particular individual had not voted yes for it, would the vote still go through?
So a very important question to me is, what is the property appraised for? Maybe the city was getting it at a discount and he could have gotten more money by selling it to somebody else, but he wanted it to become part of the city and a park. So I'm not sure he financially gained from it.
He makes more than $1, he financially gained from it. One of the things that I'd want to see is if we can see the trust. I want to connect the dots. This is Mr. G, this is Mr. G's trust, this is Mr. G's vote, and this is what the trust earned, and that's what Mr. G got. And that way, the appeals process can still happen, but we can say, look, we did everything. We've connected you to the document, to the money, and back to you.
I think both of those pieces of information would be helpful in a normal determination.
One of the things that as a commission we have to be aware of is we don't want to jack somebody's life up and mess them up unnecessarily. That we're not out here to go hunt down something. We're this impartial group, and we need to keep that in mind, that if we're going to convict somebody of something and it's going to lead to a financial penalty or removal from office or public embarrassment, let's make sure that we've done everything properly.
So I guess my point here would be, during the trial, I'd like to have a spot that the review board can call their own witnesses.
Mm-hmm.
That's an excellent point, Fred. I think too, the points that you're making, a complainant may not go down that path either. So the board, it's our responsibility to go down, and entertain all of the different scenarios that may or may not have happened and what led to the actual complaint versus how somebody's viewing the complaint themselves. So that's an excellent point, that we do need to be able to call our own witnesses. And similarly, as Meredith indicated, we need to be able to ask our own questions up front and lead the direction of the inquiry.
Krista, can you give an example of like what would be a kind of witness that you would want to you could potentially bring forth?
Do you mind asking that again? I didn't quite hear what the question was.
Like, if we were to call a witness, like where would we go in this case scenario for a witness? Like, what would be a legitimate use of calling a witness? I'm just trying to practically see how this could unfold.
I have a question relating to that, Rochelle. What about the other businesses, right? If there are other businesses that adjoin this park, this property, that might be a question that we have in that same, like you said, what are the other possible witnesses? Maybe that we have to look at a bigger picture than just the park and the trust. I don't know if that's appropriate. It's just, it comes to my mind. Maybe that's as an independent group, maybe that's a witness we need to bring in. What do you think? I'm just asking the group.
Yeah, I mean, that is kind of an extension of, I think, my question of like, if we were practically going to do this, like, who do we go to? Like, what would make sense, and what would be the benefit of it?
And whether it would be relevant.
Yeah.
Whether, I'm just asking. I mean, Meredith, do you have an opinion? Is it relevant to ask who else is benefiting from that park expanding? And we don't know that, whether it's even the the council member himself or the other person.
As I'm sitting through your discussion, I'm beginning to think that perhaps it would be more appropriate to have two meetings. One meeting where you receive the complaint, look at it, and submit the questions you have, any more documents you need, any witnesses you decide you need. The city then goes and obtains all those. Your outside counsel obtains all those. Then you have a second hearing where you post, like you did the first one, that it's a public hearing, you list your witnesses, and you go forward. I don't think that when this was drafted in 2006 that it was considered, it was thought it could be done in one meeting. But listening to your discussions, it sounds like it would definitely need to be two meetings. And as far as the witnesses that you think would be appropriate, that is entirely up to you. Anybody you think, or any documents you think that will allow you to get all the information you need to make a determination under this code is fair game. It is not my place or your outside counsel to tell you who you can and cannot invite and what information. What I think is relevant may not be what you think is relevant. You are the judge and jury. This is your decision.
Yeah, and I just wanted to visualize or imagine what that could look like, where it would make sense to actually, call for a witness. So it wasn't clear to me just yet the value in this scenario and where you would begin.
Since this is not a real case, I'll go ahead and make my recommendation. I think you could have, somebody that's related to the trust, somebody who's an expert, or explain that to you, explain how the trust works, explain whether or not this person actually got a value that was different than anyone else. Someone can actually do the outside perimeter information that is not necessarily just a code violation, but you were all asking questions along the way. Was there adjacent property? And so somebody who can give you that information would be an appropriate witness.
Okay, that's helpful.
Maybe it's just somebody with a bank who could explain that.
Perhaps we would need to speak with some of the other council members that, we would probably want to review the minutes and maybe the recording from the vote itself to hear what was discussion, what was around the discussion prior to the vote. Did this council member persuade the other council members to vote for their property? What is because at some point, if we do find that this council member did violate the code of ethics, then you have to look at the next step of, what's the so what? So is it a sanction? Is it a fine? What is the outcome of the finding? And I think the level of severity, if yes, you did violate the code, but did you also influence the other council members to vote a certain way as well? So not only did you not abstain from the vote during the discussion, did you, persuade and influence the vote of others as well? Any other thoughts around that?
What about going directly to the complainant? If they, would it be appropriate to ask them if they have witnesses that they would recommend?
I would be interested to see what a complaint would look like. I mean, perhaps as the complaint comes in, they would cite, these particular experts as well. Does that make sense? So if I'm complaining and saying this occurred and council member C didn't do this, and here's the trustee, here's the other properties that are adjacent. I wouldn't expect a complainant to provide all of it, but there may be some within the complaint itself that would warrant adding them to, a witness list.
But there wouldn't be anything in the ethics code that would prohibit us from trying to get additional information from the complainant, including, potentially witnesses.
No prohibition whatsoever. I've looked at procedures from other cities, and I will certainly incorporate some of the things they have. But they have a time frame for each side to submit a list of witnesses to you. So the complainant would submit their list of witnesses to you, as well as the person under investigation. They will have a time period to submit witnesses to you as well. So you will know how long to schedule the hearing, and based on that, you will also know if you need additional information or additional witnesses to appear.
Should we include in the procedures the ability, not necessarily the necessity, but the ability to follow up again? So I know we said 2 meetings, but perhaps you go through and you interview all of the witnesses, and then a whole new set of issues and questions arise. I know that actually happens often in like a compliance investigation, for example, that you find out, more information, and then it actually creates more questions around the scenario.
I see two ideas there. So if it brings up additional violations, then the board could be the complainant and file the complaint of the new violations, because you do have to have a signed sworn complaint to investigate the allegation. So if you have new allegations, that would be a new proceeding, but you could tag it onto this proceeding. If you are still investigating the original complaint, and you have run out of time or you need to get more information, you can always adjourn to another meeting. You can recess to another meeting, and that is not a problem whatsoever. Like today, you're going to run out of time, and so I'm going to say, hey, let's in the next quarterly meeting, let's pick up where you've left off. I will have some draft procedures, and we will continue forward with this discussion. But you can always continue it forward. You're never stuck that once the clock strikes midnight, you turn back into a pumpkin and it's all done. You do have the opportunity to take as much time as you need to reach a resolution.
That's helpful.
We might find that, the suggestion of going back and looking at other minutes and stuff like that, you could find that the particular council member who's under indictment or investigation offered something to another council member to get their vote, in which case that would be an opportunity to expand. Or according to the policy, it doesn't have to even be financial. It could be, better standing within the community. It could be enhancing somebody's career. I'll introduce you to somebody at the company who can hire you. They don't have to get something that they can put in the bank to have violated the policy. That would never happen in our city, though.
But to your point, Andrew, I know we always jest that this will never happen in our city. I think we're doing a really good job, and as led by Meredith, I think prompting these discussions makes us ready. I mean, before today, we haven't had, it's been, a very long time since we had thoughtful discussions around, a prospective hearing. And I think that keeping this at the forefront prepares us should it occur. I think Meredith does a great job of getting articles and bringing things to us that prompt and warrant discussion, so that if it does happen in our city, we're going to be mindful and thoughtful and have procedures and have the due diligence to look at what needs to be reviewed.
Yeah. And this whole process, back to the task force forming, was because there was some stuff that went on in an election here, or in a campaign here, that concerned the citizens. And that's why everything was developed to where we are today, is to deter it as much as possible, but also be ready. And we discussed that, we wanted this to kind of be like an airbag or a bulletproof vest. It's great to have, and you hope you never have to use it. But that doesn't mean that, you don't have to continuously inspect your bulletproof vest to make sure it's not expired, or that the airbag light isn't on. And that's what we're doing, is a safety feature that we've built into our city constantly needs to be inspected and tested to make sure that if it's ever needed, that it covers everything we need, and that we work together as a team. So we understand how people think on the group, and our understanding of the documents and our authorizations to go ahead with something.
I am mindful of the time. We are coming up of the closing of the meeting. So Thomas, if you will assist me with moving forward, and Meredith, if there's anything else that we need to put on the agenda for next time outside of what we're already moving forward on.
At this point, if the board does not wish to continue the meeting because we are at 1:00, you'll take a motion to adjourn, and I will make sure that prior to the next scheduled meeting, I have a draft to you in sufficient time for you to review and have suggestions back. And I will give you more than a day's notice on your articles. There were dated from, and I believe I included one that came out yesterday, but I will do my due diligence to get those to you soon.
Before we adjourn, I did have one question. Can somebody's testimony does it have to be live in person? Can it be done video?
Pre-COVID, I would say, wow, I don't know how we're going to do that. But as we are now meeting in the comfort of our own space, on our own laptops, and we can conduct city council this way, I don't see any reason why we would force somebody to come and actually sit in the physical room.
Okay, and would that have to be live as opposed to a submitted video?
Yes, because you cannot ask questions if the person's not available to respond back.
That's what I wanted.
To be extraordinary circumstances for us to be able to believe that would be proper under the ordinance.
All right, Madam Chair.
There's no more business to come before the board. If you'd like to entertain a motion for adjournment.
I'd like to take a motion for adjournment.
Second.
Second.
Quick on that.
Looks like we have Mr. Wolf and Mr. Lee as your motion and your second.
Perfect.
All those in favor?
Thank you. Meeting adjourned.
Yes, ma'am. It passed 7-0. Thank you, ma'am.
Thank you. Good job, Krista.
Thank you. It'll be a little less clumsy next time, hopefully.
You're doing great.
Yeah. Y'all have a good day.
Thank you. Thank you, Meredith.
Thank you.